So whatever the scenario, FMLA or otherwise, there's a set period of time that the employee was protected to be out of work. And then at the end of that time, the employee provides a note from their doctor saying something like, the employee is not yet able to return to work and will need additional time to recover. Some employers still believe that this is a straightforward situation. They used up their 12 weeks of FMLA, so our legal obligations are finished, and they will move to separating the employee. However, of course, as we've already alluded to, you have the Americans with Disabilities Act and the human rights laws in New York that require reasonable accommodations for disabilities. And in some situations, additional leave may be considered a reasonable accommodation. This is confusing for some employers, not those of you who are very experienced in HR and dealing with the FMLA, perhaps. But the biggest problem is that the FMLA and some of the other statutory leave programs are so carefully structured that they can be applied relatively rigidly in most scenarios, but the accommodation laws are not so specific. They're not even written with leave in mind, but they've certainly been interpreted over the years to sometimes and often in many occasions require that the employer at least consider whether additional time off from work can and should be allowed. But it is a much more case specific analysis than many of the routine FMLA or paid family leave or sick leave scenarios. So the key legal issue here, of course, is that additional leave must at least be considered as a possible reasonable accommodation. Courts and certainly the agencies have repeatedly recognized that a finite period of additional leave may qualify as a reasonable accommodation in some situations. That doesn't typically mean that employers have to grant indefinite leave to employees with medical conditions. But if the employee can provide some information suggesting that a limited extension of leave will allow them to return, the employer probably needs to evaluate that request. This is where the interactive process becomes important. Many of you are familiar with the concept of the interactive process under the Americans with Disabilities Act. If you're in New York City and covered by the New York City human rights law, there is a more prescriptive requirement to engage in a cooperative dialogue that requires some more specific handling of the situation than the general interactive process required elsewhere in New York and under the ADA. But ultimately, the concept is the same. When an employee indicates they need additional time off because of a medical condition, the employer needs to engage in this process in which they will they will participate in some form of communication or back and forth with the employee to determine the employee's limitations, the expected duration of the condition, and whether additional leave might enable the employee to return. So the legal requirement is that the employee is entitled to reasonable accommodations that will allow them to perform the essential functions of their job if there is one, and that those accommodations don't provide an undue hardship. The combination of those factors, again, makes these very case by case decisions. So, with the goal of determining whether there is a reasonable accommodation that would allow the employee to perform the essential functions of their job, the answer will sometimes be yes or sometimes no, but the most important thing that any employer can do is to go through a genuine analysis rather than automatically terminating the employee when their FMLA, for example, ends. So, what should employers do in this scenario? Well, obviously, first recognize that just because the FMLA time is up, that doesn't mean that the employee has lost their right to return to work. Then you have to determine whether the employee is entitled to consideration under those disability accommodation laws. In most cases, especially in New York, the default is going to be that you do need to engage in that consideration. If we were talking about another state where only the ADA or a similar state law applied and the definition of disability was not as broad as it is in New York, then you might more readily determine that this isn't a quote unquote disability scenario, so we don't have to consider accommodations. But since just about anything qualifies as a disability in New York, you probably are just jumping straight to the accommodation analysis.